My name is Jennifer, and I am most likely addicted to true crime. Hello, my name is Jennifer, and I am most likely addicted to true crime. Hello, my name is Jennifer. Welcome to it. This live stream was 100% not my plan for today. But here we are, and I think we should just get right into it. I woke up to this today after not being able to sleep last night, and today is not April Fool's Day. That was yesterday, and it's not a full moon. That was last night, and this is not the Twilight Zone, but I felt like my current background was appropriate. It feels like the fucking Twilight Zone. And if I sound strange, it's because I'm incredibly, I guess, emotional right now. At one point, I was physically shaking. A part of me knew this was coming. Most people believed that there was not a chance in hell that this would happen. Like, no way is this case going to get overturned. And here I sit at my dining room table. Kilo still doesn't know what to think. He's definitely not a big fan of me being as upset as I am right now. Anyway, he's under the table keeping watch. But as I sit here right now, Letecia Stauch is no longer a convicted killer. And I haven't looked at chat yet, but I already know I am not alone in the outrage. But something I told myself before I went live, I wanted to go live immediately, but instead I called Chrissy and I called Jill and I called Scout, and I have to remember this is not a thing that's happening to me. I'm just some asshole on YouTube who's been following the case for 6 years and writing about it and studying it, researching it obsessively. But this is not, in fact, happening to me. And as soon as I remind myself of that, right? I mean, but I am invested, and of course I'm upset. But as soon as I remind myself of that, I kind of get back, in the right zone, in the right lane, and I'm able to calm down. This is not happening to you, but I have put myself in a position where I am documenting it. So that part of it is happening to me, I guess, if it makes sense. Anyway, I had to remind myself that outrage for the sake of outrage does no one any good. Maybe Letecia. Can you just imagine the look on that bitch's face right now in this moment, knowing that word is rapidly spreading that her conviction has been overturned, and how happy that probably makes her? It makes me physically ill. I can't eat. I know that I should have eaten before I went live, but I fucking couldn't. I'm sorry. But like I said, outrage for the sake of outrage, it means nothing. It only brings toxicity and further confusion. And those are the types of things that Letecia Stauch absolutely thrives on. A couple of people, said that I was, right to worry about this being a reality. Most people were kind of thinking, no way, it's not possible. But I kind of felt it coming. Take that for what it's worth. I just, I was afraid this would happen because Letecia Stauch, and I've said this to you guys before, this is where that bitch shines. Letecia Stauch, through the appellate process, which is an important process, and I don't want to shit on the process. It just hurts because it's her. Using, she is the unholy queen of technicalities, but this is where she shines. The appellate process gives her the opportunity to point the finger at someone else. And that's what she's always done. If you accuse her of something, you better be ready for how she responds to being accused of something. Look, we're talking about little things like, did you drink the last of the milk and put the empty carton back in the refrigerator? Even accusing her of something like that, her go-to defense is to point the finger at you, switch the spotlight, twist and twist and twist, and wear your ass out until you finally give up and you realize, you know what? I don't care if you were the person who put the milk back in the fridge empty. Like, I give up. You win. Okay, just leave me alone. Just please leave me alone. Letecia is best on the offensive. And that is the position that these appellate arguments were written from. Letecia Stauch, with 6 years of unreasonable vengeance, like someone like she really believes that she was wrongfully convicted. I mean, of course, on some level, she knows that she wasn't. But when she starts to tell herself something, then it starts to become reality, which is why she tried to fake dissociative identity disorder. She thought she knew just enough about it that she was going to, twist it into that. And, there are so many things about this appeal that scare the shit out of me. And I hope that nobody who's in the chat right now expected me to be linear. I hope that this is what you expected, because quite frankly, right now, it's all I've got to give. And as this appeal process continues down the line and I learn more and more about it and ask more and more of the right professionals, the right questions, and just share all my research with you guys as we go through whatever this is about to become. I will be able to gather myself more and more and be more and more professional as time goes on. Right now, I'm just I'm shook. I wrote it in chat before the live started. I'm angry, I'm scared, and I'm fucking shook. Anyway, how about we go to chat? Oh man, thank you guys for putting up with me. There are so many comments. Thank you all for being here. If nothing else, this is a therapy session. Welcome to it. There are so many comments. I do have some starred from before we started, and Melissa said, why would the Supreme Court grant another trial to that killer? That family doesn't need to go through this again. Even her daughter will have to come testify all over again. And I agree, but we're going to go into the Supreme Court's reasoning. It was a panel of 3 judges. But speaking of Gannon's family, let's take this monster off the screen. I took, so the image on the right is Letecia Stauch from January 27th of 2020, which is the day that she murdered Gannon Stauch. And this is her. I snapped this from the body cam footage. So this is her looking into the eyes of one of the responding deputies on that night. And then on the left is her in May of 2023 when she was convicted for Gannon's murder. And so the way that I set it up, it's literally Letecia from January 27th of 2020, grabbing Letecia from May of 2023 by the arm and pulling her out of fucking prison. Sorry, I'm going to calm down. Anyway, speaking of Gannon's family, Scout sent me this before we got started. And this is from Landon, Gannon's mother. And this was her comment on the matter. She said, this too shall pass, Gannon strong. And, you know, I've heard a couple of people, I've listened to a couple of other live streams, people who went live immediately. And one of the people who I won't name was really nasty about the judge, about Judge Gregory Warner. And while I do believe this was a mistake on his part, I still will vote for him. He is a damn good judge. Now, one of the questions that I have for our resident attorney is, will she get the same judge, or will it automatically be given like to the chief judge in the district, which is Judge William Bain. Now, William Bain is the one who listened to Letecia Stauch's conflict argument when she had conflict with the public defenders, if you guys will remember that. And he's the chief judge in the district. So I have to assume that the case will go before him, but I don't know that for a fact yet. I have a list of questions for our attorney friend. I want to know if she's going to have the same defense attorneys. I also reached out to Josh Cellini and he didn't respond. We'll get into that later. Does this mean that Letecia Stauch will be eligible for bail? Because I think it does. We'll get into that. Will she be moved from prison back to the county jail while she's awaiting trial? And remember, she unsuccessfully sued the county jail and the mental health service providers and the food service providers. And can you imagine this smug bitch walking back into the El Paso County Jail now? And she'll walk back in like she's got a damn clipboard where she's taking notes about how this CO isn't doing their job properly, and this CO looked at me sideways, and that's an infraction. Oh God. It is the Twilight Zone. It certainly feels like the Twilight Zone, which is doubly unfunny when you think about her vampire bullshit. The Twilight Zone. Oh, okay. Sorry. Let me grab myself. I'm getting a little shaky. And a lot of people are saying she will still be convicted. And I agree. I believe that as well. There is not a defense attorney in the world that could, in my opinion, get Letecia Stauch acquitted. I do have faith right now that she will be once again convicted. That's not what's affecting me so badly. What's affecting me so badly is the evil inside this woman and the glee, the unmitigated fucking glee that monster probably feels today. Oh, man. Oh, and I see a comment from Becky. That's okay, Becky. I do want to talk to you soon, though. Maybe we'll do a study group. Oh, man. And thank you, Jill, and thank you, Scout. Sorry, I'm just reading through the comments. Becky says, I hate this for Landon, but actually I can't wait to hear guilty again and see her face hearing it. Bye-bye again. Yeah, I mean, look, I even my intro tells you I'm a crazy person, okay? This shit has melted my brain. But one of my first thoughts was, okay, so that unmitigated glee that she's probably feeling, I wonder if she's stupid enough to walk around like a peacock in prison, having had her conviction overturned. And I wondered about the anger, the potential anger that might cause in one of her fellow inmates who are serving life sentences. Oh, anyway, we're not going to continue down that path. Just know I had some real bad thoughts earlier about prison justice. And Pan Man says you called it, and I did, but I'm sorry that I did. I mean, I said from the beginning that this is a catch-22. If it happens, who better, right? But it's unfortunate. I'm not I'm not glad I called it. It was my worst fear, but I kind of knew it was coming because I'm familiar with this particular monster under my fucking bed. Unfortunately. And this pretty much sums it up for me. Just simply, I'm so fucking disgusted. Yep, absolutely. Okay, well, listen, I guess that you guys have already seen all the comments, so it's kind of silly for me to go through and put them up on the screen. And I'm sorry if I didn't see it. Just know I'm lucky to even be able to read from left to right now. I mean, even my eyeballs are shaking. I'm just kind of a mess. So, so let's take that off of the screen and let's go ahead and share my screen. Now, I am going to calm down a little bit more after this live stream, and I'm going to read this document from front to back. It's 54 pages, but I'm going to do that in a separate video without any commentary whatsoever. And if anybody has questions that they really want me to see, just find a way to make it loud, you know, be obnoxious with the number of question marks before it or something. And Andrea says, I used my true crime melted my brain cup today. Perfect for today. It is. I have mine filled with different colored highlighters, and I'm definitely going to be using it today. Let's see real quick. Melissa says, what about all the files and evidence and videos done? She knows every person talking about her, what people are saying. Will that mess up the retrial? No, but if there's anything that can be gleaned out of anything that's happened over the last 6 years, know that there is a little corner in a cell of her twisted brain that if she can use it, she will use it. You know, remember when she became her own attorney and her main goal was to get the discovery evidence into her own hands, because what she has is years of manipulation and the way she gathers information and uses it against people. She had that going for her, and that was more valuable at the time to her than the years of experience with all of her public defenders combined. The public defenders were never good enough for her. She wanted her own private attorneys, but in the meantime, she needed to get her hands on that evidence so that she could see what she could twist. Now, that didn't work out for her the way that she wanted it to, because for everything that she believes that she knows, you know, she thinks she's so fucking intelligent. You know, that's not how the system works. That's not how the trial court works. The defendant doesn't get to present all their evidence against the prosecution. You know, she wasn't able to talk about the way that she believed they mishandled the crime scene, but she really had that against them. You know, it just, it didn't work that way. And as upset as I am about her winning the appellate process, you know, like I said, if you really go back down the line, and especially the research into her background and the way that she's handled litigation in the past or accusations in the past, even if they weren't legal, the appellate process is where she shines. But she's not going back into the appellate process, right? She's going to have to face a retrial. She is not going to have to this time plead not guilty by reason of insanity. I think that she's just going to pretend that never happened. I mean, this is my opinion, obviously. We'll see what happens. But I think that she's just going to pretend that never happened. You know, before she went full on not guilty by reason of insanity, what she was trying to say was that the process made her crazy. That's what caused her insanity. Initially, she didn't want to plead not guilty by reason of insanity. She wanted to be crazy because of the prosecution, she went crazy because she was accused of murder. And now she's processed all of that. And so now it's just a regular not guilty. And the biggest defense that they're going to have whoever her defense attorneys are, with Letecia Stauch as a client, the biggest defense that they're going to have is Letecia knowing what actually happened because she did it and she's a murderer, a child murderer. She's going to be able to go through all of the discovery and try to poke holes in things that the prosecution might have wrong. And she would know what they have wrong because she's the one who did it. So it's going to be a very interesting trial. And my 6 years of obsessive research that made me feel like a lunatic half the time, I believe has value at this point. Man, a lot of people are talking about her current jail calls, and I have not looked into her prison calls. It would be interesting. I don't know that they're going to release them at this point. Because sitting here today, another thing that Letecia Stauch has manipulated her way into is she once again qualifies for the presumption of innocence. Letecia Stauch is not a convicted killer. Letecia Stauch is technically a pretrial defendant. And as the unholy queen of technicalities, she's going to exploit everything she possibly can. And not only do I hate her because of what she did to an innocent 11-year-old little boy and his family and the games that she played before, during, and after. Of course, I hate her for those reasons. But another big reason is because of what she is doing to my beloved Constitution. It really upsets me. I am a big fan of the Constitution, and she will exploit it all that she can. Also, I'm a Colorado taxpayer. I don't have a current number, but I know for sure it's in the millions of dollars of taxpayer money that Letecia Stauch has spent to play her games. Oh man. Anyway, so I'm upset for a lot of reasons, and I don't feel bad at all saying that I hate her. And Alex said, "Is this a late April Fool's Day joke?" Nope. Nope, it is not. It is absolutely not. And Catch Me If You Can says, "My mind is absolutely blown." You and me and all of us. Yeah, it's a lot. So I did see question marks earlier. Okay. Red question marks. Okay. Will Michael Allen prosecute her again? That's a good question. And the answer right now is potentially. So there's another case that's currently going to trial in the El Paso County, in the 4th Judicial District. And that is Colorado's case against Kimberly Singler, who's accused of murdering her 7-year-old son, her 9-year-old daughter, and attempting to murder her 11-year-old daughter. And the reason why I asked someone if Michael Allen would be prosecuting the Kimberly Singler case. And the reason I asked that is because Michael Allen is currently the only Republican on the ticket for Colorado Attorney General. Michael Allen is running for Attorney General for the state of Colorado. And so the answer that I received when I asked if Michael Allen would be prosecuting the Kimberly Singler case was, if not, there are people prepared to prosecute the case. And one of the people that he named who would potentially be prosecuting the Kimberly Singler case was Angelina Gratiano. And Angelina Gratiano was part of the Letecia Stauch trial back in 2023. And she was kind of I don't know. Basically the hierarchy was Michael Allen and then Dave Young and then Angelina Graziano. And when it came to the questioning of witnesses, Michael Allen generally handled like the family members and the biggest of the witnesses. Dave Young handled the more technical, certainly of the NGRI witnesses. And then Angelina Graziano handled a lot of the witnesses that I don't really know how to say it, that people kind of glazed over, like with the DNA evidence, or the gun evidence. We already knew she killed him. So that was, those were the witnesses over, the trial was several weeks, more than a handful. Um, so anyway, and Dave Young is no longer with the 4th Judicial District Attorney's Office. Another question that I've had is about Kevin Clark. Kevin Clark was an advisory witness for the 4th Judicial District Attorney's Office. And as far as I know, he is still serving as an advisory witness. And as far as I know now, and we haven't even begun to go into the damn document. Please forgive me again. But as far as I know, the only issue that caused the reversal is this issue with the juror, which means that her iPhone 8 is still in play. And the 404B evidence is also not a reason. Now, that doesn't mean that they're not going to bring it up in pretrial motions. I certainly expect them to. We're going to see pretrial motions about 404B evidence. We're going to see pretrial motions about the Fourth Amendment as it relates to the search warrant for her iPhone 8. Oh man. Anyway, so as far as I know, Kevin Clark is still there. Dave Young is gone. Angelina Graziano is still there and has 3 more years of experience under her belt. And Michael Allen may or may not be gone. That's another one of those catch-22s. I, as a resident, as a Colorado voter, not only in Colorado, but in the 4th Judicial District, I live in Colorado Springs. I want Michael Allen to be the Attorney General of Colorado as a Colorado voter. But as someone in the 4th Judicial District, please don't take Michael Allen away from us. You know what I mean? It's a catch-22. So anyway, and I see a bunch of question marks. I'm too old for this shit. I love your name. Do we know if Harley is still in contact with her mother, the monster? And I don't know if she is. I was on the phone with somebody earlier today, and we kind of touched on it briefly. And my thoughts on the matter at the time were, listen, Letecia Stauch. Letecia Stauch is one of the most manipulative people I've come across in my 50 years, almost 50 in August. Anyway, Letecia Stauch is one of the most manipulative people I have ever come across. And the idea that Letecia might be able to manipulate Harley into being in contact with her, of course it's possible. Listening to some of those old jail calls and some of the ones we haven't heard before, but still from back then, look at how Letecia gets what she wants, especially the way she brings in other people and plays them like cards in order to get what she wants out of people. And I can promise you that no part of Letecia is just going to let Harley go on about life as if Letecia is not her mother. And I can only imagine what Letecia would do to keep Harley in her life. So the answer is I don't know. I don't know if she's still in contact or not. But I know that if Harley is not in contact with Letecia, that means that Harley is fighting a major spiritual battle. Because I can assure you that Letecia is doing everything in her power to make Harley remember that she is in fact her mother. And she thinks that she was a really good mother to Harley and that she still deserves accolades for that. And Carolina says master manipulator, and that's it exactly. And Michelle says, my heart goes out to Landon today and all of Gannon's family. Absolutely. My head, my heart, my energy, my spirit, all of it, everything is going out to his family, all of them. Okay, so, I mean, do you guys want to go into, like I said, I'm not going to go through the whole document, but let's, and I haven't been able to read through it all myself yet. I've been too upset. But let's get into it together. And I'm probably going to skip around, but like I said, once I get off of this live stream, I'm going to record just a reading with no commentary. Okay, no, I can't look at the comments anymore. Okay. Let's see. Actually, we're going to start on this page. Judgment reversed and case remanded with directions. Am I sharing it on my screen? Yes. Let's make it bigger. Okay. Announced April 2nd, 2026. And then these are the panel of 3 judges and the attorneys. Okay. Defendant Letecia Stauch appeals the judgment of conviction entered after a jury found her guilty of first-degree murder after deliberation, first-degree murder of a child under 12 by one in a position of trust, tampering with a deceased body, tampering with physical evidence, and multiple crime of violence sentence enhancers. Because we conclude that the trial court committed structural error by denying Stauch's challenge for cause to a biased juror who deliberated, we reverse the convictions and remand for a new trial. So, background. The prosecution presented evidence at trial that Stauch brutally murdered her 11-year-old stepson, Gannon Stauch, in Colorado, put his body in a suitcase and left it underneath a bridge in Florida. Stauch had pled not guilty by reason of insanity, arguing that she suffered from dissociative identity disorder. But the jury rejected that defense and found her guilty as charged. The trial court sentenced Stauch to life imprisonment without the possibility of parole, plus 2 consecutive sentences for the 2 tampering convictions. On appeal, Stauch claims the court committed structural error when it denied her challenge for cause to a biased prospective juror who then deliberated. She also asserts the court erred by denying her request to suppress evidence obtained pursuant to an overbroad warrant and by admitting certain testimony by her ex-husband, Gannon's father. We agree that the court committed structural error when it denied Stauch's challenge for cause and a biased juror deliberated. As a result, her convictions must be reversed. Because it is likely to arise on remand, we also consider and reject Stauch's Fourth Amendment challenge to the search warrant. Sorry, hold on. As I was reading that, something happened in my head, and I once again pictured Letecia Stauch waking up this morning. And she's not a convicted killer. Okay. Let me get my shit together. Sorry. Where did I stop? Okay. As a result, her convictions must be reversed. Because it is likely to arise on remand, we also consider and reject Stauch's Fourth Amendment challenge to the search warrant. However, we do not reach the remaining evidentiary issue. Number 2, challenge for cause. A, applicable law. Section 610-1031 provides that a trial court shall sustain a challenge for cause on one or more of the following grounds. B, relationship within the third degree, by blood, adoption, or marriage, to a defendant or to any attorney of record or attorney engaged in the trial of the case. That's really self-explanatory. And J, the existence of a state of mind in the juror evincing enmity or bias toward the defendant or the state, unless the court is satisfied from the examination of the juror or from other evidence that he will render an impartial verdict according to the law and the evidence submitted to the jury at trial. So what that tells me, and this goes back to the last video that I did, where we had the audio from jury selection, and the juror, whose initials are MB, was juror number 12 during the voir dire process. So within a third degree by marriage, I mean, that is self-explanatory. Now, this next part with, the existence of a state of mind in the juror, evincing enmity or bias toward the defendant or the state, they did ask some follow-up questions, like, this guy over here is your son-in-law's boss. Do you think that's going to give you bias? And the juror's answer was, no, we don't discuss cases. And it appears that Judge Werner believed that was good enough. And it was not good enough. As of today, it was not good enough. And then when I found out, when the bottom really sunk for me is when I found out that they excused 92 other jurors after learning of this third degree connection to what I believe was an assistant DA. But I don't know. We'll get to that part. I don't want to guess on anything. Anyway, it wasn't good enough. Okay, let me go back actually to the comments right now, and let me just take a quick unofficial poll with like ones or twos in the chat. So put a 1 in the chat if you want to listen to the 4 minutes and 32 seconds of the audio from jury selection. And a 2 if you've already heard it and you want to just keep going through the document. So one if you want to listen to that audio again real quickly, because I do know later in this document we've got what we hear from the transcript. So a 1 in the chat if you want to hear the 4-minute audio really quickly and then get back into the document. Number 2 if you just want to go into the document. So right now it's 2-1 on the audio. Okay, Pan Man, we'll see you soon. Okay. All right. Well, it's just 4 minutes, and I think it'll help us later on in the document. Thank you for everybody who did my little unofficial poll here. Okay, so this is the audio from juror number 2.
And does the prosecution have anybody else that they wish to challenge for cause? Okay. Defense?
Got 8, 12.
Okay, 8. Okay. Give me your arguments with respect to 8. I understand that case law. We're going to move on to, I'm not going to rule on number 8 just yet. We're going to move to juror number 12.
Yeah. His son-in-law works for Mr. Allen.
Follow-up questions were never asked how that's going to impact. Statutory costs. So for him.
Yeah, I'm going to circle back to that one too. Probably what I'm going to do is not excuse either 8 or 12 at this point in time and think about it over the weekend and see where we are. I tend to agree that I don't think it's a statutory cause, and I didn't hear anything else about that fact creating an issue or conflict or something else. I agree that generally we don't have those kinds of, or I don't run across those sets of facts very often. So I just need to think about that one, and it may be that I decide it next week.
The people who objected, the court wants to inquire both those jurors.
Oh, that's an idea. I may do that. Okay. I will further question jurors 8 and 12. And then question 12, who is, or not question 12, juror 12. This is going to sound like a stupid question, but who is the son?
Mark Rowan.
Last name?
ROWA. He was assigned to juvenile in our military.
Okay. Okay. All right. Let's go ahead and bring the jury back in. Okay. Record should reflect the jury has returned to the courtroom. I wanted to follow up with some questions on a couple of people. Juror number 12, you said that your son-in-law works for the DA's office. Do I have that right? Okay. And how long's he been there? Okay. And have you discussed, or has he mentioned anything about this case to you at all? Okay.
We don't discuss cases.
Okay. That's fair enough. Then the next question is, you know that guy over there is his boss, right? Obviously, there might be a concern about how it would look. Is your son maybe, and I don't want to, whether your son is working at the same office and you come back with a particular type of verdict. Do you have any concerns about that?
It's son-in-law, not
Son-in-law, I'm sorry. Son-in-law, do you have any particular concerns that you might be influenced, maybe think that you need to come back with a particular verdict so that it works out well or better for your son-in-law at the DA's office? Okay. All rise for the jury, please. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. So what I will tell the lawyers is, by my count, juror 75 on Monday, April 3 is juror 47 over here. So those will be the first 75 jurors. Then juror 51 will comprise the first group, or will comprise the other, 30, 35 that we are bringing in on, or at 11 o'clock.
Okay, and we're back. So while we were listening to that, what I did is I went to my website and I posted the document. So should be showing on your screen right now my website, which, as always, needs work. Now we're going to have to move post-conviction. We're going to have to move Letecia from post-conviction to pending trial. But right now, if you go to post-conviction and you go to Letecia Stauch, the appeal doc is right here. You hit download, it'll give you the PDF. And it's a 54-page document, and it's there for anybody who wants to go through it themselves. Let's see. Okay. So going back to the document. Jurors who fall within one of these categories are considered biased as a matter of law, impliedly biased under subsection 1B and actually biased under subsection 1J, unless they can be rehabilitated. Upon a challenge for cause, the trial court is required to excuse them because, except as described in subsection 1J, they cannot be rehabilitated. In case law, the Supreme Court held that when an elected district attorney is the attorney of record, that section includes prospective jurors who are related not only to the elected district attorney, but also to any deputy district attorney in that office at the time jury selection occurs. That is, the statute directs automatic removal of a juror related within the third degree to any deputy district attorney in the elected district attorney of record's office, regardless of whether the deputy district attorney appeared or participated in the case. When a trial court erroneously denies a challenge for cause and a biased juror serves on the jury, the error is structural and requires reversal. As part of voir dire, the prospective jurors completed a questionnaire that included a question about whether they had friends or relatives in law enforcement. Prospective juror MB indicated that his son-in-law worked with the El Paso County District Attorney. During follow-up questioning, juror MB confirmed that his son-in-law worked as a deputy district attorney in the same office as and for Michael Allen, the elected district attorney in El Paso County and the prosecuting attorney in this case. Defense counsel later identified juror MB among the prospective jurors he wished to challenge for cause. When the court asked for more detail, defense counsel explained, quote, his son-in-law works for Mr. Allen. The prosecutor and court then made the following comments. And this is more than what we heard in the audio because this is taken from the transcript. The audio was at times unintelligible, so this takes us a little bit deeper, a little bit further. So the prosecutor says, I hate to agree with defense counsel, but the follow-up questions were never asked. How that's going to impact his ability to be a fair and impartial juror. And that certainly doesn't rise to a level of statutory cause. So we would object to him being released for cause. And Judge Werner says, yeah, I'm going to circle back to that one too. Probably I'm going to do is excuse juror MB at this point in time and think about it over the weekend, is not excuse juror MB at this point in time and think about it over the weekend and see where we are. I tend to agree that I don't think it's a statutory cause, and I didn't hear anything else about that fact creating an issue or conflict or something else. I don't run across those sets of facts very often, so I just need to think about that one, and it may be that I decide it next week. So it sounds like Judge Werner didn't believe it was statutory for cause. It wasn't, he didn't think it was statutory cause because it was a juror's family member that worked for the district attorney's office. So, and I've said this before, you don't want anybody to be on the defensive end of Letecia Stauch and be holding on to a technicality. Because once again, she is the unholy queen of technicalities, and it's just not a good place to be. Okay. The prosecutor suggested that the court ask further questions of juror MB, and the court agreed. Defense counsel objected. I think the record is what it is, and I guess the only thing, I think that there is, a difference between somebody saying, I have a son or daughter who works for the police, than, it's supposed to be than, I have a son-in-law who works for the district attorney who was actually trying the case. And so I think that's where it becomes different. Even if it was a different district attorney other than his son-in-law's direct boss who was trying the case, I think it would be different, and I'll leave it on that. Okay. The trial court brought the prospective jurors back into the room and asked juror MB how long his son-in-law had worked for the district attorney, whether juror MB had discussed the case with his son-in-law, and whether juror MB might be influenced by a desire to have the case work out better for his son-in-law. Based on his answers, the court instructed juror MB to return the next day. He was not ultimately dismissed. and I don't know if I'm, if saying this now is stepping on something that we're going to see later, but so so that happened. I think it was March 24th of 2023 is when the judge found out about this potential conflict. And at that time, the jury pool was down to 110 potential jurors. And then, like I said, for me, the bottom fell out when I found out that Judge Werner excused 92 other jurors after finding out about this potential conflict. So even if there was a technicality, I mean, come on, it should have been. Again, I still have all the respect in the world for Judge Werner. This does not change that. Okay. So under discussion. So anyway, so that person became an alternate. So there were 12 jurors and 6 alternates, and he was one of the 6 alternates. And then on the day of trial, where and you guys will remember this day well, because it was the day that Letecia was flipping off one of the witnesses. It was the first day of that. She was flipping off, I think it was the witness, her last name was Bell. Anyway, that was the same day that, that the gun expert was there. And so what happened is the expert witness, one of the jurors piped up after that witness testimony and said, I didn't realize it before, but now that she's testified, it turns out I know that witness. And so they discussed it, and that juror was removed. And that was the point at which, out of the 6 alternates, the juror whose son-in-law worked for the district attorney's office was then put on the actual jury that day. Anyway, and that's how he ultimately ended up being one of the 12. But I just don't understand how he made it onto the jury. Anyway, discussion. The Attorney General does not dispute that juror MB fell within the category described by section 1610-103 1B because he was related within the 3rd degree to his son-in-law, who was a deputy district attorney in the prosecuting district attorney's office. We are bound by the Supreme Court's determination that his bias was implied by law. And then it gives us some more case law. Nevertheless, the Attorney General argues that reversal is not warranted because it is not clear from the record whether juror MB deliberated. The Attorney General also asserts that defense counsel's challenge for cause was not properly preserved and that counsel either waived or invited the trial court's error. We are not persuaded by these arguments. Okay, let me just pick that one apart and see if I understood what it was saying. Nevertheless, the Attorney General argues that reversal is not warranted because it is not clear for the record whether juror MB deliberated. But if in the middle of trial, juror MB, so all 18 of the jurors sat in that jury box, even though 6 of them were alternates. So that means that MB sat through every day of trial in the jury box, and he replaced the juror that was removed mid-trial. So I don't understand that part. Obviously MB deliberated. Anyway, the Attorney General also asserts that defense counsel's challenge for cause was not properly preserved and that counsel either waived or invited the trial court's error. And to me, what that means, which, take it or leave it, I'm not an attorney, but I'm going to ask one. So the Attorney General was arguing that when Tellini said, Tellini brought up this challenge for cause that MB was, had a son-in-law that worked for the district attorney's office. But there were no follow-up questions. And Judge Werner even mentions that when he says that he's going to table it for later. He says, well, I didn't hear any arguments of why it would be a problem, basically. Obviously I'm paraphrasing. And at that point, one would expect that the defense attorney would pipe up and continue to argue that this juror needs not be part of the jury pool. But he didn't, apparently. But if it's a statute, if it's a required challenge for cause, I don't think the defense attorney really has to do that much, because it's really on the court to do that. But again, I'm going to ask for further clarification, because I'm not an attorney. But that was apparently the state's argument was that Cellini didn't argue it well enough, and there are technicalities. Anyway, MB deliberated. Our review of the record demonstrates that juror MB deliberated. Indeed, the trial court granted Stauch's motion to settle the record on this point, removing any doubt. And then there is a footnote. While the Attorney General attempts to dismiss this portion of the record as new material, the trial court's order settling the record was accepted as part of the supplemental record on appeal. It is therefore properly before us. Okay. The challenge is properly before us. The Attorney General first argues that Stauch failed to properly preserve her challenge for cause because counsel did not explicitly cite the appropriate section and did not correct the trial court's purported misunderstanding that the challenge for cause was based on something other than a statutory ground. The Attorney General further asserts that defense counsel's comments after making the challenge for cause suggest that the challenge was based on juror MB's actual bias, subject to rehabilitation, not his implied bias based on his relationship to the prosecutor. For the reasons discussed below, we conclude that the court considered and ruled on a statutory challenge for cause under the appropriate section. Therefore, the challenge is properly before us. I'm sure these judges did not want to overturn this conviction. I'm sure that they didn't want to overturn this, but how could they not? When you look at the actual case law and the actual statute and the third degree rule, it's just, how could they not? I feel bad for the people who had to write this opinion. Okay. To begin, we recognize that defense counsel's challenge for cause potentially implicated two different subsections. Recall that the statute requires the court to sustain a challenge for cause on one or more grounds, including implied bias based on a relationship to an attorney of record, and actual bias subject to rehabilitation. That is, defense counsel could have based his challenge on juror MB's relationship to the prosecutor or his state of mind resulting from that relationship. Given this context, we reach two conclusions from the record. First, we conclude that counsel's stated reason, quote, his son-in-law works for Mr. Allen, end quote, was sufficient to trigger a ruling under subsection 1B. Second, even if it were not clear solely from counsel's challenge to juror MB on which part of the statute counsel was relying, we nevertheless conclude the prosecutors and the court's subsequent comments brought subsection 1B squarely into play for purposes of our review. As the prosecutor correctly observed, at the time of the challenge, neither attorney had asked any questions to elicit whether juror MB had, quote, a state of mind evincing enmity or bias, end quote. Without these questions, there was no way to tell whether juror MB should be excused for actual bias. Having recognized this, the prosecutor continued to note that the challenge certainly didn't rise to a level of statutory cause. In this context, we conclude the prosecutor could only have been referring to statutory cause based on implied bias under subsection 1B. The trial court's subsequent comments likewise suggest its awareness of the distinct for-cause challenges available under subsections 1B and 1J. The court first said, quote, "I don't think it's a statutory cause," end quote, and then noted that it, quote, "didn't hear anything else about the fact creating an issue or conflict or something else," end quote. These comments indicate a cursory and improper rejection of a challenge based on the relationship itself under subsection 1B, followed by a separate consideration and rejection of a challenge based on a biased state of mind under subsection 1J. Despite the Attorney General's arguments, we do not read these statements as demonstrating confusion about the nature of defense counsel's challenge. Instead, read in context, we conclude the trial court's statement, "I don't think it's a statutory cause," reflected the court's mistaken belief that juror MB's implied bias based on his relationship to the prosecutor, as distinct from his actual bias as a result of that relationship, did not trigger mandatory removal under the appropriate section. In other words, the trial court was not questioning whether defense counsel was making a statutory challenge for cause based on the relationship itself. Instead, and critically for purposes of our review, we read the trial court's statement as expressing its inclination to deny the challenge for cause on both grounds. When the trial court ruled on the claim raised on appeal, it is properly before us. Defense counsel's subsequent argument that the situation might be different if the juror's son-in-law worked for the police or for a different district attorney other than his direct boss who was trying the case does not change the result. As the Attorney General acknowledges, that argument went to whether juror MB should be excused for actual bias, and the trial court had already rejected the challenge under the section. As a result, defense counsel was under no further obligation to restate his objection. I'm going to skip over the last couple of footnotes because, again, we're not going to go through the entire 54-page document. But as soon as I stop this live stream, I'm going to hit record and record a full reading of this document. I want to get through this section, and that's where we'll stop for the live stream. But, I want to talk about it some more. Anyway, likewise, that defense counsel did not cite the appropriate section is of no moment. The Attorney General relies on case law in which a division of this court declined to consider the denial of a challenge for cause because defense counsel did not specifically cite the section. But in case law, quote, defense counsel moved to challenge the juror for cause because he would place authority on the testimony of a police officer over anybody else, end quote, not based on the mere existence of a relationship covered by the statute. This case is distinguishable. Defense counsel's initial challenge for cause succinctly stated that juror MB was related to the prosecutor. Unlike other case law, counsel did not argue that juror MB might have actual bias in favor of the prosecution. And as discussed, even if defense counsel's comments left any doubt, the prosecutor and trial court expressly acknowledged and dismissed the possibility of a statutory challenge based on the relationship itself. On these facts, we conclude the trial court was on notice of the particular ground for the challenge, even without a specific reference to section 16-10-1031B, and then it cites more case law, which I'm going to skip over. Let's see. Yep, I'm going to leave the rest of this for later. Once again, let me get back to my studio and the comments and you guys. Did I have you? No, I didn't have you on a blank screen. You guys could see me you guys could see me, or you could see the document on the screen until I came back to the studio, I think. I hope. Anyway, okay, I've missed most of the comments, but I'm going to scan back through them real quickly, just looking for those really loud questions. So here is one from Carolina. Did Judge Werner not know that would cause a strong or worthy appellate issue? And he apparently didn't think that it would. We're all in the position of, Monday morning quarterback now, looking back, listening to the audio, looking at the transcript and the appellate documents. And I can honestly say, looking back at it, well, and we just read, I mean, it used the word mistake when talking about how the judge ruled on that particular challenge for cause. It was a mistake. The judge made a mistake. And I feel like if he had known he was making a mistake, he wouldn't have done it. But nevertheless, he made a mistake. And I do not believe he would have done it, obviously, if he thought that it would cause such an appellate issue. But looking back and knowing that he released 92 other people after learning about the potential, that blows my mind. Okay, let me just look for some. Okay, here's well, no, I already did that one. Okay, if you asked a question while I was reading and I missed it, just go ahead and pop it in there again if you don't mind. And I see Scout. Melissa asked, can the AG appeal this decision? That's an excellent question that I don't know the answer to. Let me just take a moment to put it on my attorney. I have a list of questions for the attorney. And if one of the mods could put the link in for the attorney, the command on Nightbot is exclamation point and then blink. So our resident attorney is going to be Peter Blink. He is very busy, but he has opened himself up to answer my questions at a minimum by email. Hopefully he'll come on the channel, but he is, he's a named partner in a big criminal defense firm right here in Colorado Springs, overlooking the courthouse. And I don't know that I'm going to have constant access to him the way we had access with Chris Welch, but we do have access nonetheless. So I'm gathering my questions. Whenever I really value their time over there at Black, Blink and Associates. I also know the other named partner, Cliff Black. We've worked together for more than a decade at this point. I value their time, and they've never once made me pay for it. So I want to make sure that when I do ask the attorneys these questions on behalf of the channel, on behalf of the research, that I am prepared, precise, and productive. So throw those questions at me. And when I do, have the communication with the attorney, I will make sure and ask those questions that I feel like are appropriate. Thank you for putting that in the chat. And Andrea says, I bet the judge wishes he would have dismissed that juror. Oh, I'm sure. I can't imagine being in Judge Gregory Werner's robe right now. Once again, he's one of the many people that my head and my heart go out to. I am not angry with him. That would be ridiculous. I mean, it sucks he made a mistake. He absolutely did. And I hate to say it, but the Colorado Supreme Court, this panel of 3 judges, was right to overturn it. It just makes me sick that Letecia Stauch. Listen, a lot of people wrote her off, going back to the presumption of ignorance with this monster. So many people write her off because she is obviously an idiot. Letecia, I've said this 100 times. Letecia Stauch is nowhere nearly as intelligent as she thinks she is, but she's a lot smarter than people give her credit for, and that's part of what makes her dangerous. Her ability to manipulate, her ability to take things like the Constitution or other people's employment contract or the rules that other people have to follow that benefit her in any way, whether that is the Constitution, whether that is her contract with any school district when she was employed as an educator. My God. Anyway, she is it's what she does. And so it makes me sick that she's using the Constitution that I love so much, and that she was able to technically not be a convicted killer right now. Oh man. Okay. Jill. Okay. Anyway, so when I get off of here, how long have we been here? Just about 1 hour and 11 minutes. I'm going to go ahead and sign off for now, and I'm going to take a little break, and then I'm going to record the entire document. If you want to see the entire document, on paper or use it in any way, it's on the website. It's easy to find. I hope that you will continue to gather with me to continue processing what happens, what it means, as we follow this road. Expect a lot more content out of me, whether I like it or not. But I will talk to you guys again very, very soon, and look for that video later tonight. Bye for now.